May it please the Court, James DeSimone on behalf of Jie Hao and Xue Lu. I'd like to go to the very last point the counsel was making that Judge Reinhart was inquiring, because it is a misstatement on finding of fact 30, which is found in the excerpt of the record 25. Ms. Hao testified that she suffered severe emotional distress when she was first contacted by Thomas Powell on the telephone. This was prior to letting her attorney know. This came out of the blue for her. This was prior to engaging in any sting operation. And Judge Marshall properly made a finding of fact in 31 that after that phone call, that's still in 30, after her first phone conversation with Powell, Hao experienced anxiety, headaches, sleeplessness, and fear. So the assertion that there was no harm prior to the sting operation, as made by counsel for the United States, is just absolutely belied and proven wrong by the record. And I thought I would start out with that. In terms of this parade of horrors, that if someone cooperated with the government, then they could turn around and sue when they're involved in a sting operation. This is a very unique situation. This is a situation in which the sting operation is against an official acting in his course and scope of employment with the United States of America. Your normal crime is not going to be against a government official such that you're going to have liability against the United States based on that conduct of government officials. So in terms of sticking with the facts of this case, Ms. Jie Hao should be compensated because, as she testified in trial in front of Judge Marshall, she was present there. It was Xue Lu whose testimony was taken in Hong Kong and presented. As she testified in front of Judge Marshall, she agreed to be fitted with a wire and to have her interaction videotaped. She didn't consent to any of the conduct by Thomas Powell. And the most important part of this is that Mr. Powell, in the course and scope of his employment with the United States, interfered with her right to asylum and her right to a fair adjudication of the asylum. And that interference was so profound that it delayed an adjudication of her claim for 5 years. 5 years.
But the district court on ER 30 said that Powell's conduct was the actual and proximate cause of the nearly 8-year delay. So do we need to remand for the court to take a look at the last portion of it, the last 2-3 years?
I don't believe so, Your Honor, because I think that the harm, if you look at the record and the harm to Ms. Jie Hao in the letter she wrote to then Judge Lu, shows how that 5-year delay before the immigration proceeding started getting rolling again. And I think that overall the conclusion that, oh yes, well it took 8 years for her to get asylum in that instance would not in any way diminish the damages. And I would suggest to Your Honors that this case has been proceeding for now 16 years. I mean, from the date of the conduct of my clients, when Ms. Xue Lu came into my office, prior to anything happening with Jie Hao, it's been 16 years. So unless a finding of Judge Marshall is held to be clearly erroneous, I think that it would be an injustice to, again, remand and cause further delay. And that would include on the finding of bad faith, Your Honor. Because you would have to show, you as a panel would have to have a definite and firm conviction that somehow Judge Marshall made a mistake in the finding of bad faith. And the cases cited by the United States of America in their reply brief show that you can look at the underlying conduct of the government official, and I'm referring specifically to the case of Barry v. Bowen. You could look at the conduct of the underlying official involved in order to have that finding of bad faith. And in this instance, you have, and the court didn't focus on this itself, honestly, but you have Powell's conduct, which can also constitute some of that bad faith. And all of what Judge Marshall found, that the totality of circumstances were in bad faith here by the United States of America. And when the United States of America argues in reply that they have to have mens rea, that there has to be a specific ill intent, as counsel argued up here, they're wrong about that. What you have to have, the standard is whether or not the United States of America proceeded in a reckless fashion, raising a frivolous argument. And the consent argument was frivolous, and it was offensive.
How is the consent argument frivolous? I mean, this is a difficult situation where you can't recover on the battery, but you can on the intentional infliction of emotional distress arising out of a similar incident, what happened during the operation. So at some point, you've got to tease that apart. So the government, post-remand, took the position that, look, plaintiffs haven't shown an injury that's distinct from the solicitation as opposed to the battery. That's not inconsistent with the scope of the remand, is it?
So now you're focusing not on the consent argument, but the battery versus the intentional infliction of emotional distress. I would submit, Your Honor, that the Sabao case is very instructive here, because it's not as if you have to show. In Sabao, you had one meeting with a United States general where he told a family that their deceased husband and brother was a crook, was a felon, and was going to go after the brother in his doctor's license and accuse him of wrongdoing. And the court held that those comments were defamatory. And of course, defamation is an accepted tort under the Federal Tort Claim Act, just as battery is for purposes of our case. And what the 9th Circuit said in Sabao is, even though those comments were defamatory, you look at the method in which they were delivered, and they were done with an intent to inflict emotional distress. And when you read the testimony of Xue Lu that's submitted as part of the record here, Xue Lu says that while Mr. Powell was touching her, that he was saying, if you don't like this, I'm going to deny your green card. So you have a situation where, yes, the physical touching does set up the coercion, that's a necessary element of Civil Code 52.1, as well as, of course, distinct from that, the threat to deny the asylum, which is not exempted. So in terms of if you have, under California law, and this is a case that was cited in the reply brief, the Ash case, if you have two concurrent torts acting to cause a single harm, the fact that both parties are fully liable for the harm that's caused. And when you look at the testimony of Xue Lu in this case, and of Jie Hao, yes, in the moment, of course, no female is going to want to be touched by a strange man who has that type of power over her, and that's very deleterious. But if you look at the long-lasting harm here to each of my clients, the long-lasting harm was that he got into their apartment. How is he there? By virtue of his power as an asylum officer. What was he abusing? That power as an asylum officer to approve or deny their asylum. And what was so offensive, why the harm lasted
well,
for 15
what you're really
years.
going to is the merits, and obviously you prevailed at trial, and the record supports that. What I'm focusing on is the court's findings that the government litigated the case in bad faith, that it was vexatious, that it was wanton, it was oppressive. So one of the findings is that, look, the government persisted in an argument that's contrary to the 9th Circuit ruling. And I'm not sure that I see that in the record where the government argued contrary to the scope of the remand.
Because, Your Honor, the court did not only argue in their closing argument, the counsel for the United States did not only argue in their closing argument that you should somehow have less damages because of the battery. They argued that you cannot recover at all on these causes of action because battery was involved. And once the 9th Circuit ruled in Xue Lu 1 that the injury from the denial of a violation of 52.1 and the intentional infliction of emotional distress was an injury distinct from the battery, making that argument was completely frivolous. They were arguing that my clients should not recover anything at all in their closing argument. And I was the trial lawyer in this case. And so that particular argument was frivolous. Now, what the cases say, just because the government makes arguments that are not frivolous, okay, so maybe theoretically you could argue that there should be a discount. But why? I mean, in other words, it's a misunderstanding of basic California tort law when you look at the substantial factor test, where when you look at for something to be a substantial factor, it doesn't have to be the only cause of the harm. And yet they were arguing in the face of prior precedent and clear California law that somehow they should be absolved of damages for the interference with my client's rights because there was also a battery involved. And that is offensive, Your Honor. I mean, why should the United States get a pass? Because not only did he deny them their rights to asylum and try to predicate their being granted asylum, which gets them a green card. I mean, that's their ticket to enjoy the freedoms of the United States of America. If they get that, if that asylum officer approves, it's done. They have their green card and they could stay here. Yes, there's an appeal process if there's denial, but that was so important to each of them. So why should the United States get some sort of discount or pass? Because Mr. Powell was also engaged in a battery at the time that he was intentionally inflicting emotional distress on these individuals and denying them their rights and violating 52.1. The answer under California law clearly is no, you don't get a discount. If you've got two torts acting to cause a harm, each of the tortfeasors are fully liable for all of the harm caused. The cases cited in the reply brief in no way disabuse anyone of that notion. I mean, one, this is an intentional tort. So while it hasn't been, we cited the 9th Circuit case which says that you can have an intervening factor overcoming the initial harm with an intentional tort. There may be some doubt of that in California law, but when you have an intentional tort, it has to be, the intervening event has to be so far outside what is contemplated that it would be unfair to hold the initial tortfeasor liable. But here, what were the harms to the clients? The harm to Ms. Jie Hao, of course, was that she didn't have her asylum application adjudicated in a timely fashion, and there was a delay. The harm to Ms. Xue Lu was that she, all the emotional distress that she suffered. And again, you have a judge who is guided by the Xue Lu 1 opinion, sets forth very carefully in her finding of fact and conclusions of law the harm that each of these individuals suffered as a result of the denial of the rights under 52.1 and the intentional infliction of emotional distress, and states that the harm that she's causing relates to those violations. It's presumed, this isn't a runaway jury award. This is for what happened here. I mean, it's a substantial award, but $500,000 and $700,000 for each of these individuals is not so far afield that you would say, oh, there would have to be some injury from the battery. And I would grant you this, Your Honor. The United States has never identified an injury that resulted from the battery that was distinct from the interference with my client's rights. This isn't a case where there was a battery and someone suffered a broken arm. You could say, well, the broken arm's from the battery. Well, that didn't happen here. And without them being able to show exactly and tease that out, this is where the discount should have been, there was no basis for Judge Marshall to do so. And I think that if you look at the totality of the circumstances, Your Honor, what Judge Marshall is really looking at is you not only have to look at the technical legal arguments that are being made by the defense, you've got to look at the totality of the circumstances of the underlying conduct of the client they represent. I mean, they're representing, through the United States of America, an individual they know is guilty of interfering with their rights to an asylum and inflicting emotional distress. He was criminally convicted. Both Xue Lu and Jie Hao testified in the criminal case against them. So when you look at the totality of the circumstances, even if you could question one or two, and reasonable minds might disagree on one or two of the findings of bad faith, this panel would have to have a firm conviction that Judge Marshall, who heard all the evidence, was clearly erroneous in that finding of bad faith. And I would submit to you that the case law holds that you could take strongly into account Powell's underlying reprehensible offensive conduct that occurred in the year 2000. And we are now 16 years later. And what the Equal Access to Justice Act does, Your Honor, is it levels the playing field for a firm like ours who litigated this case for 16 years.
Was there a component of the damages that awarded fees prior to June 2000?
Under the, yes, but under the statutory minimum, for the $125 an hour, there was a small amount of time that was incurred.
Why would that be subject to, why was this case subject to that?
There's a different, in reading the case law, Your Honor, there's a different standard. In order for us to get our fees at the market rate, there would have to be a showing of bad faith. In order to get the fees under the Equal Access to Justice Act for the initial conduct at the lower level, you would just have to show that the United States took a position which was not justified. And in that instance, Your Honor, I think we can look at Powell's conduct, which was prior to that June of 2008.
I thought the section that she relied on didn't apply to intentional torts. She found that we were not entitled to attorney's fees under 52.1, and she found that the United States acted in bad faith. The reason why I think that you can go back, as she did, to the beginning is because Powell's conduct started in the beginning, and Powell is acting as an agent of the government, and the government is stuck with that conduct. And it was the government defending that conduct over such a long period of time in the totality of circumstances.
Time has expired. Thank you.
Thank you very much, Your Honor.